Hello, boys and girls. It seems there is a whole heck of a lot of confusion right now over protective orders. How do they work? What do you call them? How do you respond to them? Do you file a counter-protective order? Can you file a counter-protective order? What would be the point of filing a counter-protective order? Etc., etc., etc. In Oklahoma, from the best of my understanding, there's two basic ways to get a protective order, such as is being sought by the family Roth. The first way, it requires somebody to be in a relationship, essentially. Love, sex, or family are the three basic ways. Victims of rape can get protective orders against the rapists. Family members can get protective orders against family members. And if you're dating someone or otherwise intimate with them, you can get a protective order. Or if you were dating like an ex-boyfriend or something like that, you can get a protective order against. So, well, I don't know. Maybe I shouldn't say that. Maybe there has been love interests between Interlaid and the family Roth. Who knows? Who really cares? I'm assuming that what's going on is a protective order that does not require it. And that would require not one, but two acts of stalking. And I don't think there are two. Now, I don't honestly think you could make a very good argument that what Interlaid did was stalking, would qualify as stalking when he went to film Patty's car. But you could make an argument about it. That is, it's a possibility. You can, however, make a really good argument that what Patty did, sending his two little thugs to Interlaid's house, was stalking. There are legal definitions of it. I'm just saying that from my perspective, from my training, from my experience, I don't think that what Interlaid did was stalking. So, but there must be another one, or else she's just going to lose outright. Apparently, she alleged it because she got the ex parte temporary restraining order approved. So we're going to see. I'm still saying that Interlaid desperately needs an attorney. Please, if you see this, Sergeant Interlaid, get an attorney. One messed up thing about temporary restraining orders is that they do require you to surrender your weapons. Yes, it sucks. I understand there is no due process, but it's for a very short period, and the needs of the state and the victim have apparently justified it. I don't agree with that particularly, but I understand it. So Interlaid is required to turn in his firearms, and typically the way that is done, at least in California, is you go to a gun dealer, you let them know that you've got a temporary restraining order, they take it, and then they won't return it to you until you show that you no longer have that temporary restraining order or permanent restraining order. So yeah, it's messed up, but it's only 7 days, and hopefully Sergeant Interlaid wins. The correct response to having someone file a request for a temporary restraining order or a protective order against you is not to file a counter. It's you file a response. You get your attorney, you lay out the facts to the attorney. The attorney will pick the appropriate facts to place them into a pleading called a response, and he will then serve that response on opposing counsel and file it with the court, and the court will have an opportunity to read the response. And if it's a good response, it may color the court's opinion in advance of the hearing so that you come into a sympathetic court rather than a neutral or hostile court. That is the point of it, because the court has read the petitioner's pleading in this case. I guarantee you, and I also guarantee you that the petitioner's pleading does not frame Sergeant Interlaid's actions in the best possible light for Sergeant Interlaid. So, I'm not familiar with anything in law called a counter pleading or a counter motion. I've heard of counterclaims. That's where if you sue a person for, like if you sue a painter for for doing a bad paint job, they can counter sue you basically for, well, you didn't pay me, so the two issues get resolved together, etc. I don't know. I don't think that Interline would have a good protective order. So what he should do is, number one, file a response, and then if Interline thinks that he has grounds for a protective order and wants to get one, then what he would have to do is file his own motion for a protective order hearing. And he would have to show that there were at least two acts, independent, separate acts of stalking, et cetera, and all that fun stuff. So the wannabe YouTube lawyers who are saying that what you do is you file a counter protective order, they're silly. They don't know what the hell they're talking about. Take it from a family law attorney with 1 year of experience. That's not what you do. You file a response. If at the end of that, if you think that you want a protective order against the other person, then you would file your own motion for a protective order or request for a protective order. So I hope that clears it up. Again, I can't stress this enough. Sergeant Interline really needs to get an attorney. And if you have the ability to reach out to Sergeant Interline, I suggest you do so and make him aware of how terrible it could be, because if he loses this, not only does he have to turn in his firearms now, but if he loses this protective order hearing, up to 3 years of no firearms. So I don't think that our good Sergeant Interline really wants to be without his firearms for 3 years. And I strongly recommend that he gets an attorney. This is what attorneys are for. It's to protect your rights. Get an attorney and have him whoop the hell out of Roth. So thank you very much for watching. Have a great day.